Okay.
Much obliged.
Yeah, my lord.
Yes,
My lord, I beg to mention item number 9. My senior is absent on health ground. Matter may be fixed for admission hearing.
My lord, in this matter, I am for the petitioner.
you're for the petitioner.
Yes, in this matter, item number 9. So this
Item
matter
9.
may, yes, this matter may also be
You're
fixed.
the respondent.
Yes,
Yes.
my lord.
This matter may also be fixed on 19. On same, yes, 19th of February.
Your Lordship, I beg to mention item number 7. Your Lordship, conducting counsel is observation on medical ground. Lordship,
7.
yes. Your Lordship, matter may be fixed on 21 of this month, 21 February.
Received 7.
Lordship, Lordship, we have called Elshia, Lordship. Elshia has already received from
Received.
Yes, Lordship.
Your Lordship, matter may be fixed on 21 of this month.
21.
Your Lordship. Your Lordship, I also beg to mention this item number 11.
Item number?
Item number 11.
11.
11. Your
Yes,
Lordship,
please.
same counsel is out of counsel and medical, out of
You're for
station.
the petitioner.
Yes, sir.
On the other side,
Yes, I am for the respondent.
you're for the respondent.
Your Lordship, matter may be fixed after 4 weeks.
4 weeks. 4 weeks.
My suggestion.
I beg to mention item number 2.
2.
Item number 2.
Yes, please.
The matter may be fixed on 15th of March.
You're for the petitioner.
Respondent.
You're for the respondent.
Yes,
What-
Lordship, I am for the petitioner, Lordship.
Yes.
Lordship, no issue, Lordship. On 15,
You have no
Lordship.
objection.
No objection, Lordship. Lordship, just interim may continue, Lordship.
Term is extended after 4 weeks.
15 March.
15 3.
15 March. Obliged.
Much obliged.
May I please, my lord?
Yes.
My lord, I have filed one bail application yesterday. So matter may be take up as a last item will be on.
Bail
my lord.
application.
Yes, my lord.
4:30
Yes, my lord.
today.
Yes.
For today.
May it please your lordship. Lordship, I beg to mention item number 1.
Item 1. Yes.
With the regard to the file, the file has been misplaced. We are in searching for the file, your
You're for
lordship.
the petitioner.
I'm for the respondent, your lordship. For the
Oh,
state.
Okay. Criminal petition.
Yes, your lordship. If I may pray, this matter be listed after 2 weeks, your lordship.
What about the petitioner?
I have already taken consent, your lordship. Deeply.
May I please, madam? My lord, this is a, my lord, application under section 482, my lord. Seeking, praying for the quashing of the, my lord, session case, number 28 of 19, pending trial before the learned session judge UPA, my lord. My lord, if I go through these records, all those things, materials on record, my lord, what is disclosed, my lord? Is basically, my lord, this
It is
particular.
framing of charge.
No, my lord, it's at the stage of evidence. Ma'am. It is at the
At the
stage of
stage of evidence.
evidence. Ma'am. So, my lord, what happened, my lord? Basically, this FIR was lodged under the pressure of the, my lord, family, my lord, relatives, my lord. What happened, my lord? From the charge sheet also, my lord, it can be seen, my lord, it is amply clear, my lord, from the charge sheet also, my lord. This petitioner number 2, both the petitioners, my lord, they were in extramarital affairs, my lord, relationship, my lord. Since for the past,
Any witnesses were examined?
my lord, now it's going on, my
The victim was examined.
she has given the, what happened, my lord? After that, my lord, they have mutually settled their case, my lord. Now they have entered into marriage, my lord. I have enclosed the marriage certificate here also, my lord. Now what happened, my lord, since at that time, they were having the extramarital affair. So there was a lots of issue from the petitioner's wife's side also and the relatives of the petitioner number 2 also, my lord.
To call for the LCR, otherwise it is difficult.
My lord, then, my lord, it's only here only UPI, my lord, then may I pray, my lord, this matter may call it
482 CRPC.
29, my lord, of this.
482 CRPC for quashing of the charge sheet in connection with session case number. Session case number and
My lord, session case number 28 of
28/2019.
State versus Kumar Tajo.
Pending in the court of CGM.
Session just UPI.
Session judge UP. Learned additional is appearing for the respondent one. The victim?
Victim with petition number 2, my lord. Join application.
Call for the LCR, a scan copy of the LCR. 29/2.
29.
29/2.
Okay, deeply obliged.
May I please, my lord?
Yes.
My lord, pendency of my lord,
Yes,
second
for the
my,
petitioner.
no, I am for the respondent, my lord.
Yes, for the respondent.
For the respondent.
Well, the pendency of the my lord, RSA 5, they petitioner file an application, a CRP for my lord, staying the execution proceeding, my lord. And in the meantime, my lord has delivered the judgment, my lord. If my lord remembers, my lord's judgment, my lord. And against the judgment, my lord, the
RSA. It's
RSA,
in
my
a
lord.
criminal
My lord,
revision against this matter.
no, my lord, this is a civil revision petition, my lord. They filed
Yes. Civil revision petition.
praying for staying of an execution proceeding, my lord. Pendency of that RSA, my lord.
That is disposed of already.
Yes, this was pendency of that RSS, my lord. They filed this current, my lord, CRP, my lord, for staying the execution proceeding, my lord. By now, my lord has delivered the judgment, my lord. And against the judgment, my lord, they have preferred an SLP before the Supreme Court, my lord. That was also dismissed, my lord. So in this manner, civil revision petition, nothing remains now, my lord.
Yes, please. Matter may be infractuous, I think.
Yes, basically, my lord. Or my lord may
Can be closed, lordship.
my lord may close the civil revision petition with those observations, my lord. My lord judgment and the Supreme Court's my lord dismissal order, my lord.
Third Mr. Prudential Learned Counsel for the petitioner and Learned Counsel. Sole respondent, you
Sole
are
respondent.
sole respondent.
Not respondents, my lord.
Respondents.
Respondents. Is submitted by Learned Counsel for the respondent that this criminal revision has been preferred
The civil revision.
I'm
Civil
sorry,
revision.
civil revision has been preferred against the, to stay the impugn execution order, no?
Yes, ma'am.
Yes.
Dated 4/7/23.
18/5/2023.
Yes,
Page 21, my lord, of the
page 20,
one, my lord.
okay, dated 4/7/23, passed by the learned additional deputy commissioner Matsuka. In execution case number MKA, capital MKA slash JUD dash 104 slash KEB, then KKO slash 2023, then capital lane. By this time, the RSA RSA 5 in bracket
No,
April
madam.
22.
Pendency of the RSA, my lord. Lordship will kindly see at page 62, my lord. The RSA was already filed. Pendency of the this RA, my lord. And my lord, and kindly page 65, my lord. RSA, my lord, hearing was completed and judgment was reserved, my lord. At that stage, my lord, they have filed a page 65, my lord.
Page 65. Heard argument of both parties, reserved for judgment and order.
During that period, my lord, they have filed a civil revision petition, my lord.
When the case was fixed for judgment,
Lordship, during the pendency of the judgment, we have filed a civil revision.
civil revision. During the pendency of the, when the case was fixed, RSA number 5/AP 2022 was fixed for judgment. This revision petition has been preferred. However, by this time, the judgment has been delivered on
On my lord, 26/9/2023, my lord.
26/9 is 23. Which was dismissed, no? Which
Aye.
was dismissed. Subsequently, the petitioner has preferred SLP before the Supreme Court,
Which was dismissed on my lord 4/1/2024, my lord.
which was also dismissed.
On 4/1/2024.
What's the date?
And the second paragraph, my lord.
Second-
In the first
second
page,
para.
in the first page itself, my lord.
4/1/24. So this criminal revision, civil revision, infructuous, it is put off accordingly. The other hand, learned counsel for the petitioner also submits that he has no objection on the prayer of the respondent. So the matter which is disposed of being infructuous, okay?
Oh, yes, sir. That one. But I will take back the judgment, my lord. Of your
What is
lord,
judgment?
my lord's judgment, my lord.
Okay, you can see the deluxe copy and this. Deluxe copy, keep it on the back.
Yes. May I, Lordship? Lordship, this is a joint petition under section 482. For the joint petition, that is by petitioner number 1, who was the complainant, and petition number 2 and 3, and for they were the alleged accused in connection with the Likavali PS case number 30 of 2022. Lordship, what has happened in this matter is that Lordship here the complainant, that is petitioner number 1 and petitioner number 2. They were in a extramarital affairs, Lordship. What happened, since their relationship were, since the petitioner number 2 is a married man, their relationship were objected by the board of family members. And since there were several meetings that they should stop their affairs between them. But what had happened, Lordship, on the date of the incident, that the petitioner number 2, along with
LCR receipt,
L- LCR,
scan copy of LCR.
May I, Lordship?
Yes, yes.
The petitioner number 2,
Petitioner number 1,
one is the complainant, Lordship.
complainant.
Yes, complainant.
Okay.
Yes,
Petition number 2,
one is the alleged accused,
accused.
Uh,
2 is the accused.
2 is accused, and 3 is, or 4 is also accused. Like
3 also accused.
accused, Lordship.
Okay, 2, 3 accused.
2, 3, and 4.
4.
And
All
4 is-
accused.
all accused. Lordship, what has happened on that, since this petitioner number 2 and 3, they are the residents of on the Itanagar. Lordship, what has happened on that fateful day, they went to Likavali, that is in Silapatar, Lordship. From there, Lordship, the petitioner number 1 call up petitioner number 1, that is the complainant victim, to come over there. And
The case is at the stage of
it's charge has been
charge
framed,
was framed.
charge has been framed, and also been during the course of the petitioner number 4 has been discharged by the learned trial court below, Lordship.
4 has been
He
discharged.
has been discharged.
So no case against
Hmm.
him.
And Lordship, petitioner number 3 has been charged under 204 and 365.
What is the charge order? Order,
Lordship, in the Lordship, I'll just take to page 28. The investigation of officer also has,
page 28.
yes, Lordship, 28. The top, Lordship, the accused so and so is the petitioner number 4. He was, the investigation officer has charged him under 204.
204.
Hmm.
What 204? It's a complaint case.
No, Lordship, it's a FIR case, then complaint case. FIR is in Lordship, page 16.
Ground of the case under section 15. It's found in this plan, this would not have this person to come daily. Last line of page number 27. You see, under the above fact and circumstances, a prima facie case under section
Then
307, 365
354A 506
is found well established against the accused persons Pritam Pangi Dolo.
that is the petitioner number 2, Lordship.
2. Okay.
And-
Loma Dolo,
Loma Dolo and
Tony Riva.
Tony River, that is petitioner number 4. But Lordship, coming to the next page,
Loma Dolo, what
Ye-
about? He is not the petitioners here.
is the petitioner, his petition number 3, Lordship.
Then 2, 3, 4 against the prima facie case found against them.
Yes, that's what the finding of the investigation officer, Lordship.
Yes.
The investigation officer has charged petition number 4, that is Tony River under section 204. Lordship, that right? The page 28.
Okay, charge was framed by the court.
Charge has been framed, Lordship. After filing of this complaint petition, since there was no stay by this honorable court, the trial has,
Where is the order of charge?
that Lordship, the honorable court has seek from has seek the status of the case in the last order, Lordship.
That may be there in the LCR, Your Lordship. We don't have the.
Properly maintained.
If Your Lordship allow, I will try to find out from the record, Your Lordship.
The date of framing of charge
Yeah.
and under what sections the charges were framed.
Okay, Your Lordship. Your Lordship, CC speaks, CC that is 25th, 8 and 7, 25th, 8, 2023. But after that, there is no order, Your Lordship. It's part of the, not the
25,
25, 8, 2023, Your Lordship.
23,
Yes, Your Lordship.
when the charge was framed?
It was fixed on 25, 8, 2023 for appearance for and CC. So after that, Your Lordship, it is not there in the record. That has not been sent before this court, Your Lordship. So, Your Lordship, that may be called for then. Under what section he has been charged? Under what section the charge has been framed?
There is no any order, the
Yes.
charge has been framed.
No, Your Lordship. Latest order is my learned brother is saying CC charge has been framed, but it's not a part of the record, Your Lordship. Only that fixing for CC consideration of charges is there, Your Lordship. Which was on 28/7.
But, It is submitted by learned counsel for the petitioner that charge has already been framed against the petitioners. 2, 3 and 4, no? 2, 3 and 4,
Yes.
charge has been framed.
No, against Lordship, 2, 3, 4 has been discharged, Lordship, in while framing.
Force has been discharged.
Yes, Lord.
Where is the order that
That Lordship, I've just been informed, but,
you have been informed?
Mhm.
Okay. And the 4, against 2 and 3? And the petitioner number 4 has been discharged. Though LCR has been received, but no order has been available in the record regarding framing of charge against petitioner number 2 and 3 or discharge of petitioner 4. The which court, CJM, no?
District and Session Judge, Pasigat, Lordship,
District and Section Judge,
Pasigat.
the Section Judge, Pasighat is directed to furnish report whether charge has been framed. When the charge has been framed and the present status of the case number.
इधर में हो।
Executive magistrate, no? Session Judge. Order is Executive Magistrate Likawali.
Your Chief Judicial Magistrate has recorded the 164 statement.
that's fine. You see the order.
GR case number
Dated
21,
11/12/22, the matter so there is the order. The executive magistrate Likawal. Then. In the matter so answer. Then executive magistrate. No, magistrate, it will be written, magistrate, and process of the Then they will. Okay, PGM passing application. Of the order, PGM passing.
Hmm?
Those things.
Before the chief judicial magistrate.
Passing.
Yes, your lordship.
In connection with Likawali PS case number 30/2022. You have not mentioned the case number, sessions case.
Lordship, since when we had filed this matter, it was pending before the learned CGM, CGM.
CGM.
Since the
Any case number?
case
The
number,
only
Lordship,
Likawali PS case number,
Kabali PS case number.
that is,
The GR case number is given, your lordship.
sir,
In their agreement only, GR case number 21/22.
21/22.
Yes,
Page number,
your lordship, they have mentioned in their agreement, your lordship.
India,
Agreement, your lordship. Page number 68. In other pages, there nothing is there. But however, in the course list, they have annexed.
okay, GR case number 21/22. Corresponding to, in brackets just, corresponding to GR case number 21/22.
Yeah.
21/22. But any session case number? That is now pending in the sessions court. Session court, Pasighar. Pasighar sessions court. So maybe a session case number.
Lordship, allow me to again find out, because perhaps your application is filed for the bail, your lordship, in the session. So your lordship, again, allow me to go through it, whether it is pending before the session court or before the CGM. Your lordship, the latest order fixing the date for CC is by the CGM, your lordship. Your lordship will find in this order.
CGM,
Chief Judicial Magistrate, GR case number 213/22, your lordship.
213.
Yes, your lordship. Your lordship will find here.
That's been committed.
It's not committed before this CGM only, your lordship may find the order, latest order, your lordship, according to the record.
CGM hall.
Lordship, in that-
07 travel by the. session
Yes, your
court.
lordship.
Lordship, in that matter, the matter may be fixed after 1 week. I'll take out the CTC copy and file an IO. That will solve.
Because CGM is fixing it that for CC, your lordship. That is the issue.
Then maybe charge sheet has been
I'll-
filed under.
Yes, your lordship.
travel by the magistrate.
It ought to have been committed to the session before the session court, but session court case number is not there.
Place the matter after 1 week.
Yes, Lordship.
Let him get the instruction, your lordship.
Lordship, in that matter, Lordship, since the trial has not begun, Lordship, the matter may be stayed till returnable date, Lordship. Because like, once the,
Sorry, the record is not available, the proper record. That is not,
Until that as per the record, the Arms Act is there, your lordship.
Arms Act is there.
Yes, your lordship.
Whether
If it is,
charge
al-
sheet has been filed included in Arms Act and 307 is also there.
yes, your lordship. If it is altered,
That
then
is-
there is a case. But if it is not altered, they don't have a case because Arms Act fall under
Lordship, here
against
the,
society.
the
For
complaint,
for the status report, no? Status report of the case. So CGM better,
Yes, your lordship.
CGM.
CGM.
CGM,
CGM/, session court date, because again,
No, your lordship, the record will be CGM, even if it is committed, CGM is in the better position to give the information, your lordship, whether it is committed or not. Deeply obliged.
item number 5, Lordship, I am for the respondent, Lordship.
anybody complainant?
I'm for the petitioner.
Yeah, for the complainant.
For petition. This for admission hearing, Lordship, this matter can be disposed of today, since Lordship, the matter is an negotiable instrument pending before the trial court, Lordship. And they have obtained an interim. Whatever has to decide, Lordship, the lower,
Petitioner is the accused, you are the accused.
yes,
You are the complainant there. Complainant in trial court.
yes.
482 for what? For quashing.
Yes. Actually, my lord, we have not received the affidavit in opposition yet, my lord.
What?
Affidavit in opposition, we have not received it yet.
Affidavit in opposition.
Yes, ma'am. So,
My sister said they're saying I have to file and reply. That's all. But Lordship, since this is a reply will not be necessary because this is a complaint case we have filed before a learned trial court under section 138 of NIA, Lordship.
That is disposed of.
Not
No,
that
that
this
is
way,
pending.
pending. It's
Oh,
for-
against the, okay.
And Lordship, if you go through the last order 228, there's 2011 of 2023, where the
23?
2011 of 2023, Lordship, 20
20,
November
2011, yes.
By this order, Lordship, the Honorable has stayed the proceeding, Lordship.
Okay, stay the proceeding.
700.
What is the further proceeding of?
So,
my lord, since we have not received the affidavit in opposition, my
They are
lord,
not ready to file any complaints. I mean, affidavit. So you can argue the matter will dispose of today.
actually, my lord, the leading counsel is engaged in court number 1.
Who is the engaged counsel?
Takam Sunil,
Yes?
T Sunil.
in this case, Lord, we can pass it over because after it's obtaining an interim that since because whether we have a case or not, Lordship, for that reason only, Lordship, they have not come before this honorable court with clean hand. Why, Lordship? Because they had filed an IA under section 258 of CRPC saying there is no case against them. But the lower court below, Lordship, are dismissing there is a dispute of fact, and that has to be decided during trial of the court, during trial of the case.
It's a check, bouncing of
Yeah,
check.
check bouncing of case. What the court has to take whether check was given to him or not, and whether after
Whether
bouncing
it
of
is
check-
signature in the
and
check was issued or-
that check was issued or not, then that all has to be taken care
On
by the
trial.
trial court, Milo. And that,
Definitely
My
trial.
lord, the matter may be passed over for time being since.
For the time being.
Mm.
Okay, because of
that can be done. Below.
LCR was called for, LCR received, your lordship.
LCR received.
Yes. Charge frame under section 406, 465, 468, 471 of IPC.
You're the petitioner.
Yes.
Yes, please.
Uh, this is second criminal petition. Earlier one was withdraw for some defective. So there was not annexed FIR copy. Today I have annexed the FIR copy.
Trial copy.
FIR. Earlier
There
the
is no any FIR.
FIR is there, but earlier the petition, criminal petition was not enclosed the FIR copy. So the honorable court has give a direction to withdraw the case and annex the FIR copy. So
Okay.
I filed the fresh.
You have filed a fresh, this
Yes.
one, fresh one.
Yes.
Where is the copy of FIR?
FIR, this is in the page number 13,
Page number?
page number 13.
That is not legible. Typed one?
Type, yeah. May I please to read? With due respect, I am to inform that on 8/03/07 at around 9:30 hours, one Sri Sengbum Taji, who is accused, has taken one motorcycle, TVS, Vector red color, registered number AR 15027 from me, near National Cinema Hall, Nahalon for urgent work at Bandura. But till that, he has not returned the said motorcycle. No any information today above 16:30 hours. Suddenly found at G station, and he stated that said taken by Bagang Tapa, who gone to Sepa. This is the FIR.
This is the FIR.
Yeah, in this case, the party has amicably settled outside the court. Present status of cases, PW, this is evidence stage.
The cases at the evidence stage.
Yes.
When the charge was framed. The last order was 11/5/23. After that, no. What's the present status of the case?
Now, presently, status of case, PW is evidence stage.
8/8/23.
Yes. So.
There is an order by the learned Chief Judicial Magistrate. The charge has been framed on
Lanet?
Judicial Magistrate Pars Class JMFC, your lordship.
Dated?
Dated, your lordship, 30/11/16.
30/11/16. 30/11/16, yeah?
Yes, your lordship. Learned Defense Counsel so and so is present before the court and submitted that the charge may be framed accordingly. Learned so and so is present before the court, perused the record and found that the white order dated so and so, the learned, that means on 13/8/2007, the then learned JMFC has framed charge under section 406, 465, 468, 471 of the IPC against the accused person Sri so and so, present accused. Accordingly, the offense was explained to the accused person to which he pleaded.
07. The
Yes.
charge was framed 13/8/07.
2007, yes, sir. It's long time back, you know.
So where is the charge, charge form? Then how many witnesses were examined?
It's let me go to- Um, 1, 2, 3, 4, 5, 6, 7. 7 witnesses.
7 witnesses already have been examined.
7. So during premature, I pressed to extract out the section 465, 468, 471, but learned JMFC has not inclined. Actually, here the fact of case is that I have not.
After the 7 witnesses have been examined.
Yeah.
What is this in charge sheet?
Actually,
How many witnesses remain to be examined in the case?
your
Charge sheet also, they have
that's it.
not annexed in my
Uh,
petition.
my lord, your charge sheet I annexed last previous petition, criminal petition, but it is not visible at all. Better, your my lord, I would like to pray before this court. Maybe call the record. Because
LCR is the same.
same only, not visible at all.
Yes, Mr.
Yes, your lordship.
It is sufficient, I think. It's okay, no?
Your if it is legible, no issue, your lordship. But in the present application, they have although not annexed, but LCR is there. In LCR,
That is why.
yes,
LCR is there
yes, your lordship.
and there is a typed copy.
Yes.
So any problem with this, I think?
It is also not much clear.
8th day of 2019. The last witnesses were examined in the year 2019.
Yes, your lordship. Perhaps, your lordship. It's a very old case, perhaps, your lordship. The FIR was filed on 2007 itself, March 2007. They have annexed the FIR copy in the present petition. 10/3/2007, the FIR is there.
Okay.
Your vehicle, lost vehicle, that Ali's vehicle was recovered only. But this accused person and the accused person complainant, informant, they are close related.
Lordship, from the FIR, it transpired that the complainant has lent his vehicle to motorcycle to the present accused on a on a pretext that he would.
Dispose of the matter in the trial
No,
court because
here
this
actually.
case is about to
Yeah,
dispose
dispose
of
of
the last stage.
My lord, here section is section wrongly section they insert this section. I have not
Sanction.
section the section given me a charge against me, the section which I initially I pressed to extract out from this one when appointing charge, but the honorable Leonard JMFC has not inclined. But in this, I would like to make it clear that I didn't sold any vehicle to this present complainant. In spite only the section which is supposed to attract me 406 breach of trust. But I didn't sell any the motor vehicle to this present complainant. The section it is not attract to me.
Nothing is there in the record. So you can say charge form,
Yes, your lordship.
whether 2007 under this sections, whether charge has been framed or not.
Yes, your lordship. But your lordship, the order which I have read out, your lordship, there that order itself is from the JMFC. At that time the present JMFC has passed the order.
2007.
Yes, your lordship.
That is.
The charge has been
Okay.
framed under the certain sections. Now the question here is, your lordship, this case they are not challenging this case, assailing the merit of the case. That this section has been wrongly charged or not, your lordship. They are not on the merit of the case because this is a joint petition. They jointly filed this.
Call for the LCR. No.
Better.
That is the LCR only, your lordship.
The scan copy, no?
Yes, your lordship.
Nothing is here, scan copy. This is the rocks, make it as a rocks and send.
Then your lordship, updated LCR copy of the LCR.
To see whether framing of charge, the form is there or not.
Yes, your lord.
Not to answer, no answer. Better to call for the present status. of
Yes,
the
yes.
case.
Updated NCR.
Updated. LCR. This is
my
not
lord-
updated LCR, that is. Charge form. Third, Mr. So and so learned counsel for the petitioner and learned additional PP. Though LCR, scan copy of LCR is received. But, and it appears that charge was framed in the year 2007, no?
2007.
30/11/2007. But the form of charge is not available in the LCR. The magistrate, no?
Yeah, JMFC, Judicial
CPM.
Magistrate First Class. Judicial Magistrate
JMFC,
First Class, Your Lordship.
UPI.
UPI,
UPI.
yes.
JMFC UPI is directed to furnish the, updated. Before that, right? It is also not. It also cannot be ascertained whether when witnesses were examined after 2019. The JMFC UPI is directed to.
One more submission there.
Yes.
Till the pendency of case, the matter will stay.
No,
Because proceeding maybe goes on.
the. It's directed to, furnish the present status of the case along with updated,
LCR.
LC. Just another 2 weeks.
Yes, Your Lordship. Oblige, Your Lordship.
My lord.
Yes.
My lord, I am for the petitioner. And my lord, today I thought they will file reply. So I have not come prepared. So a short date may be given for final disposal of the hearing, since they have informed me that they will not file the affidavit in opposition.
Short date.
Short date. Fixed date on 19.
Third, Mr. Swansea, learned counsel for the petitioner and learned counsel appearing for the respondent. Learned counsel for the petitioner prays for time to finally dispose of the matter, which is 7 plus the matter 19.
For admission here.
Ma'am,
Yes, yes.
my lord, I am for the applicant. My lord, this is a bail application. Filed under section 439 of CRPC. My lord, in connection with mapping PS case number 1 of 2023. Your Honor, alleged offense is a 419, 420. Read with section 66D of IT Act, Your Honor. Yeah, my lord.
Did you receive?
Yes, Your Lordship.
And my lord, kind of,
What is the allegation against you?
my lord, page number 10, it is FIR.
Page number 10.
10, it's annexure B, it's the FIR, my lord. May I read without that? My lord, with the subject cited above, I am lodging an FIR against one Sri Manuranjan Gogoi, data operator contingency staff of ERO office for misusing the Eronet apps of ERO mapping and illegally includes electors in the e-rolls of 19/13 landlord and 19/39 Kamayar polling station, due to which the abnormal increase of electoral were seen in draft. E-roll of 19 Yaping Assembly constituency without the knowledge of ERO, the official might have involved in doing such illegal activities, which has malified intention.
Yes.
Therefore, you are hereby requested to make an inquiry and investigation. My lord, except section 420 is the non-bailable section. The other section is the bailable section, my lord.
Which is available? 420 is available.
Non-bailable. Except the 420, other two sections are bailable sections,
Other two sections?
are bailable.
Which are those sections?
Those sections are 66D,
66D of
D of IT
IT.
Act, yeah.
Okay.
And
Another?
according to section 81 of the IT Act, it is overriding the IPC, so the 420 is wrongly invoked in this case.
No, no, it's a wrong submission.
And my lord, the accused
Case
person
was registered under section 419 and 420 IPC, not IT section.
66D2, your
66D
lordship.
of IT
D
Act.
also there?
Yes,
Yes.
but then that won't override, the submission matter is absolutely wrong, your lordship. How can IT Act override IPC, your lordship? There are ingredients with regard to 422, your lordship.
No, as per the section 81 of the IT Act.
IT Act.
Yes, it is
These are
overriding the
bailable,
IP
no?
Yes, bailable section. And section 420 is the cheating by personation, and section 66D IT Act also as cheating by impersonation. So the accused person was, my lord, arrested on the 15th of December. Now he is in judicial custody for 59 days today.
So 1 day.
So-
No, your lordship. This is the submission, if I clarify, your lordship. This was a complaint made by the electoral registration officer, your lordship. This is not the FIR, your lordship. The FIR, your lordship will find subsequently at page number 14.
Page number 14. But
Yes, yes.
in page number 10, that is written as
14.
FIR.
An FIR and complaint was made before the OC police station, your lordship. Enquiry was conducted. Subsequently, on enquiry, the enquiry was made as an FIR.
To superintendent of police.
Yes.
An inquiry report. This
Yes.
is inquiry report.
Yes, subsequently, this was registered as an FIR, your lordship. Now, the basic, what has actually happened, your lordship will see. If your lordship will come to paragraph 2 of the inquiry report, your lordship.
The case was registered under section 419, 420.
420 and 66D IT.
66D, that is bailable, like.
Yes, that is very, 420, your lordship. Now,
419 and 420.
yes,
The mandatory periods are 60 days.
Yes. your lordship, if I may tell your lordship what the case is
Charge sheet
about.
has not yet been submitted, no?
No, because there are many accusers who are yet to be taken into custody, your lordship. On the last,
That is mandatory period is 60 days.
yes, your lordship. No,
After 60 days, he is entitled for default bail.
they can come for default bail. There is no objection to that. Because they have not briefed your lordship about the case. What has happened was, in this case, your lordship, this is a contingency worker. The election in the state is coming up, your lordship, in the month of March 2024, your lordship. Now, during the registration and of electorals, what this person did is that he had taken into the ID and password of another person, your lordship, who was the in charge, your lordship.
Allegation is there.
Allegation is there. Your lordship, even if I may brief your lordship, what has happened that he has enrolled 700 proxy voters. Thereafter, on inquiry, he has also admitted to the fact that he was offered an amount of 45 lakhs to do this by co-accused, some of the co-accused, your lordship.
My lord, that is
He
the
has
allegation only.
No. He has.
Until and until proving the allegation is.
That's a different thing. The charge sheet will be filed. Charge sheet will be filed only on the statement and admission under 161, your lordship.
It is a
Now, what has happened is that on he has admitted to the fact of 45 lakhs, your lordship. Only certain amount has been recovered back, your lordship. The rest of the amount has not been recovered. Thereafter, your lordship will see that his involvement in this case, prima facie, there is absolute full case, your lordship, under 420, 419, even 66D, your lordship. He has stated that he admitted to the fact that he has enrolled number of 500 voters, your lordship. Now, where did this 500 voters ID come into existence? On whose approval were they enrolled, your lordship? Without any interference of an official, higher officials, Your Lordship, this cannot be possible.
That can be ascertained in the trial of the case,
Yes.
my lord. This,
The bail has come in the during the pendency of investigation, Your Lordship.
an accused person was arrested on the 15th. Now today, the
15th?
Yes.
15th of December. Now today is 14th of February. Now 1 day is left for completing of mandatory period.
That
One
is
day,
Let
only 1 day.
let them,
Only 1 day.
in that
Tomorrow.
case, let this petition be kept in abeyance till it becomes default. Your Lordship can in that ground.
And accused
Quash it,
will be
because
released on tomorrow.
even on
only
day,
because
Your Lordship is
the
not
release
aware.
order will be
Your
passed
Lordship
tomorrow.
is, just a second. Your Lordship is, even to by tomorrow, if the charge sheet is being filed with a prayer for applying of a supplementary charge sheet, even then default does not come into existence, Your Lordship. Even in the day of, in a period of a day, Your Lordship. There are prima facie, Your Lordship, he is also not disclosing to the fact that on which are the IDs, where did he obtain 700 IDs, Your Lordship. It's not even of 10 IDs, 700 IDs, Your Lordship. In 2 constituency.
But in the mandatory period, it's
Also-
almost completed.
also
almost.
The period of
Yes.
detention. that
Yes,
I was
detention,
saying.
period of detention
Only
is almost completed.
that
Yes,
period,
yes,
that much.
yes. What I'm trying to prize this honorable court is that if he is if he has the right of default bail, Your Lordship, that will be after the mandatory period is over, that will always be invoked. He can always invoke the prayer for default bail,
No,
Your
I'm
Lordship.
not filing.
But
I'm
the-
not praying for that mandatory. Now 1 day is left
See,
for the mandatory period. Only 1 day.
What I'm trying to
It can be
explain is
considered-
absolutely that.
It can be considered, my lord.
No,
Only
how
1
can
day,
a
1
default
day.
prayer be considered when the mandatory, even for a day?
It's
Or
not over, no?
yes,
No, it's not
After
over, but
1 day
1 day.
will-
Tomorrow,
yes.
my lord.
Your Lordship can fix this matter after a week otherwise. If they are, because they themselves are submitting
my
that
lord,
they are not
tomorrow
praying
it
on
will
default bail.
complete. Tomorrow itself it will complete.
They can approach the
Tomorrow. And,
appropriate
accused will be
court
released
for
tomorrow
default bail.
only, not today.
By this time, justice may come.
Yes,
Then-
So,
So
my
what
lord,
to do today? You will dispose of?
yes, Your Lordship. On the other occasion, what I'm trying to submit before Your Lordship is that their prima facie case against the accused, Your Lordship. While granting bail, and also Your Lordship will see the the character of an accused when he is granted bail. He has been arrested after an issuance of NBW, Your Lordship.
Your
Through the
lord-
entire period, Your Lordship, he was absconding. And
NBW.
yes, he was arrested after issuance of
The
the
case is pending in the court.
NBW. During the investigation, Your Lordship,
Investigation NBW. Who issued NBW?
magistrate, Your Lordship.
So,
Because he was not cooperating. That's what I'm trying to apprise this honorable court, Your Lordship.
in the stage of FIR,
He is also a contingency worker, Your Lordship.
was issued illegal.
He has, Your Lordship will see his own statement. He has stated that while investigation, he has used half of the amount running to Goa, Goa to Mumbai, Mumbai to Andhra Pradesh. And when he came for signing of the bail petition, that's when he was arrested, Your Lordship. There is absolutely full charge of he absconding and not cooperating with the trial, Your Lordship.
But my lord, what
if
I
the prosecution, if the IO fail to submit the charge sheet,
By tomorrow, yes, there is a mandatory period that it has not completed, Your Lordship.
on 16th. it will
Ah,
be
yes,
better.
yes,
My
Your
lord,
Lordship.
my lord, is only 1 day is left, and what I'm
Fix on
submitting for
16th.
this honorable court is my lord is that lordship is that, my lord, that detention period of detention considering the period of detention, it is 59 days. 1 day is left, and accused will be released tomorrow, not
It
today.
will take instruction where the charge sheet has been submitted.
Yes,
City is busy. I
And
have
my lord-
added additional PP.
My lord,
Praise for 1 day time where the charge sheet has been submitted or not. List the matter on 16.
my lord, the applicant is a
Deeply
mother of
obliged.
the mother of the accused person, and she is ready to furnish the adequate bail bond, purity and bail bond. So, my lord, in that
The
condition.
CD may be returned, Your Lordship, in that case. CD may be returned, Your
My lord,
Lordship.
my lord, I
CD
have a-
may be returned.
my lord, I have a small.
CDB retained.
Ah.
definitely CDB.
My lord, in that case, I would like to withdraw my petition. Actually.
You want to withdraw your
Yes,
petition?
yes, I would like to withdraw my petition because tomorrow it's going to over the mandatory period, so I'll go to the law court.
Trial court.
Yes, trial court, I'll file. the-
Learned Counsel, Mr.
Sri Lanka.
Submits that. Learned Counsel for the petitioner. The petitioner, the applicant. Wants to withdraw the application. Learned additional PP has made no objection on the favor of the petition.
Your Lordship, if the record reflects that the CD was submitted before this body, because
Just he wants to withdraw.
Yes.
Doesn't matter.
deeply.
Disposed of one withdrawal. Ten. Yes,
Your Lordship, yes, Your Lordship. In this matter, Your Lordship, the petitioner seems to be absent. However, the service on respondent 3, 5, and 6 are awaited.
None appears, no? None appears for the petitioner have a loan additional duty, yes. Training is present. With service report regarding respondents. List the matter after 3 weeks? 3 weeks. Well.
Lordship, on last occasion, the CD was called for, so we have the CD, Lordship.
Did he
Yes,
receive?
yes, Lordship. Petitioner counsel was present in the morning, Lordship. I think he is busy in another court.
Pass over lordship for, well, he's in his legs in court number 1.
For the time being?
For the time being.
Lordship, actually, service also not been completed, Lordship, upon respondent, private respondent.
Which one, please?
Item number 12, my lord. My lord, may kindly see the order sheet where I've already served the notice. However, there is some remark. I have served the notice as per their address, proper address in the FIR. FIR is at page number 120-21
Page number,
of my petition.
yes.
This, yes. My lord, their address is reflected in the FIR they have lodged before the. Page number 121 is the FIR. It starts from page number 120, Annexure 4, impugn FIR, which I've challenged in this criminal petition under section 482. My lord, may kindly see page number 121 on the top, serial number 1 and 2.
121.
Yeah, my lord, yes. Their present address and their permanent address, they're same. And I've duly served them, but remarks have been come in some Hindi language that they are not residing in that place. So my lord, I'm in a dilemma what to do at this stage.
Where is it? The report?
Office note, yeah, in the very front page of the records. Office note of 9/2/2000, recent office note.
2 and 3.
Yes, my lord.
Received where
Yes.
concerned. Written note, section 46, C3.
My lord, there is not section, that must be sector. their
Sector.
sector. Yes,
Sector
Sector-
46 में C3 tower PWD name.
yes. So my lord, at this stage, I am confused now how to serve the notice.
Lordship,
Or it may be deemed served as per section 27 of the.
46.
it can be served as lordship that concerned jurisdiction or PS lordship.
Yeah.
Concerned PS of the lordship, concerned jurisdiction lordship of that area. Lordship.
Haryana.
You
Maria.
can try that one. Yes, lordship.
If such order may be passed, then I can again take a fresh step.
Interesting.
My lord, another thing, my lord, since the day one of this petition, my lord, I've been praying for interim. My lord, see, on the face of the, my lord, my case is squarely covered by the landmark judgment of Bhajanlal and the recent of Niharika instruction. My lord, this FIR, the charges inserted are the 323, 341, 506 and 34. My lord, this is FIR is a counter FIR of after the there was a disturbance in the matrimonial relationship. So my lord, now
What is
the
FIR
FIR, my lord, 121.
121.
Yes, it starts from page number 120. Contents of the FIR at page number 121. May I read, my lord?
Yes, sir.
My lord, at serial number 12. On 19/6/2023 at 1600 hours, a written complaint received at PS Balukpong from one Sri Vinod Kumar Singh, 61 years old, son of such and such, such and such, such and such, residing at such and such, to the effect that his son's wife, Srimati Unnati Rajesh Singh, Unnati Rajesh Singh is the one of the petitioner here, wife of Harshil Kumar Singh, that is respondent number 3, the son of this complainant. Her family members from parental side and Sri M. at the security officer of NIPCO Kimi has conspiring to physically harm him. Him means the son and his family members as Srimati Unnati Raje, wife of his son, was found to indulge in extramarital affair and adultery with Sri M. Ate. First time both of them met when he was on official tour for Arunachal Pradesh as chairman NIPCO, that is the complainant. He along with his family member stayed in NIPCO guest house at Kimi on 27-28 of 4/2022. Srimati Unnati Raje exchanged her mobile numbers with Sri M. Ate and started unduly indulging with him. Again on May 2022, she took his son to Arunachal Pradesh on the pretext of tourism, but her hidden plan was to meet Sri M. Ate in order to indulge in physical relationship with him. While on travel between Pinjoli Point and Balukpong in the late evening of 17/5/2022, Unnati went to the roadside bushes areas telling his son that she wants to go to bush side for urination. Her husband had already noticed in the vehicle that she was continuously chatting with Sri M. Ate on WhatsApp and deleting the messages instantly. He had got some suspicion about her activities. He followed her to bushes cautiously. Sri M. Ate was already there in the bushes. Both of them were caught in very objectionable position. After that, her husband immediately objected to it and told his wife that he will inform her parents about this. Her wife and Sri M. Ate pounced on and attacked, thrashed his son very violently, saying that if you inform anybody about this matter, they will remove from their ways. My lord, this is on the face of the FIR. My lord, one thing very significant about this FIR has been filed on 19/6/2023. This incident occurred on the year 2022, which is a lapse of 1 year, 2 months, to be very precise. My lord, what happened is this, my lord, my lord, what happened is in the year, this petitioner number 1 and respondent number 3 were married in the year November 2021. After their marriage, matrimonial relationship went into trouble due to physical and harassment from respondent number 3, that is the complainant and their family, for physical abuse as well as dowry torture. The petitioner herein filed an FIR before the Chhattisgarh, that is my annexure number 1, which starts from page number 21 to 62.
Three accused, no? 2, 3 and 4, respondent, 3 accused. You are the petitioners, no, you are the accused.
Petitioners are the accused.
Accused here.
My lord, this is an afterthought of this. And now the charges framed in the FIR are 323 for voluntary causing hurt, which is a non-cognizable and bailable offense. And 506 is also bailable and non-cognizable offense. 341 has been inserted for, which is a 341 is for wrongful restraint. My lord, on the face of the FIR, where did I find wrongful restraint? Husband is not a kid that he will be restrained. It is solely fabricated FIR just in the verge of vengeance and personal vendetta that the wife's family has been made accused in this whole FIR just to harass us. As already the cases are pending in the Chhattisgarh, in the state of Chhattisgarh.
The case is pending in this state of
Yes,
Chhattisgarh.
matrimonial case as well as an FIR, yes. So my lord, this is an afterthought, and they have registered this FIR just to harass these petitioners. All of them have been made accused in this, all the family members of the wife.
They're regularly attending the court.
No, my lord, the status I have not been yet updated. I don't have the updated status. However, matrimonial cases have been going on since 2021.
Charge has been framed. In this case, charge has been framed.
No, notice stays only, my lord. So this is a frivolous.
After just FIR has been lodged.
Yes, man. And the police has been constantly harassing us. And my additional affidavit must be there in the record also. Recently, we have went to the police station complying with the section 41A. 3 of us, namely, we have appeared before the IO, and we have given all our documents relating to their accusations. We have tried to justify our stand on this regard. So on additional affidavit, my lord. Unnati Raje, the main petitioner, along with Ajay Singh and Ankit Singh, we have appeared before the IO already. And now the rest of the petitioner is the father of the case, who is 61 years, where is Ajay Singh? Who is 48 years Singh, and Usha Singh, the parents of the petitioner. They are just simple, mother is a homemaker and father is a businessman in Madhya Pradesh, and Nidhi Singh and Utkarsh Raj Singh. One is giving his college exams, and Nidhi Singh. And they were never in this scene. However, the police investigator have sent them notices. So it is very difficult for them to come from Madhya Pradesh to Balukpong. It is more than 1,000 kilometers, my lord. So, my lord, basing on this FIR, which is just an afterthought and a fabricated one, just to take personal revenge and vendetta against this family, at least till the returnable death, I may be given some protection. Already we have appeared before the IO. The wife.
You're not in the state of Arunachal. You're in, I think you were in Madhya Pradesh.
My lord.
Then
And even the complainant, my lord, he
Lordship,
was just
in
serving
our
as a
lordship, we have received this case day, lordship. This is 5th September, lordship. I don't hear, lordship, there's no record of their statement, lordship, whichever my learned
have
counsel that
appeared.
you
My
are
lord,
submitting.
my
lordship.
affidavit in the OC himself, the IO himself will
Yes,
receive
lordship, we
the,
require, lordship, updated CD, lordship.
till then, my lord, some protection.
No, lordship, because, lordship, here
The
allegations
charges
severe,
are,
lordship.
even if the charges for the sake
Lordship-
of argument, they are not very serious offenses, my lord. And we are complying with it. And we are living in we are a permanent resident, and we have received the notice. We are not absconding anywhere.
Lordship, moreover, lordship, these sections are lordship, compoundable, lordship. They can compound, lordship, here, lordship.
My lord,
three-
there is no chance of
three-
compounding the offenses because husband and wife, they are already their matrimonial deterioration. And due to
case
such
is under
physical.
investigation, no?
Lordship.
Charge sheet has not yet been
Not,
submitted.
not lordship, not yet lordship. And lordship, because lordship, the investigation could not be completed, lordship, because they are not cooperating, lordship, as per this case diary, lordship. And so now my learned counsel submitting that they have appeared before the IO. That record we have not available right now. So
My lord-
we should call for lordship.
My lord, I have
updated
filed
case
an
diary.
additional affidavit with the receipt and all.
Additional.
I
affidavit.
cannot suppress this material fact before this court, my lord. Additional affidavit is there, my lord. I have,
That will, they should come in,
my lord, yes.
Whether you have appeared. before
Annexure
the
5
IO.
series, my lord. And this is it has been duly received by the officer in charge of the Balukpong PS, my lord. My lord, I agree with the learned PP. Let the updated city maybe call for, but till such time, I may be given such protection so that the police won't
Lordship,
unnecessarily
they are
harass me
submitting that,
on the
Lordship.
basis of this frivolous
Lordship,
FIR.
their story like that, Lordship, both the Lordship, this husband and wife, not Lordship, in the good terms for the past few years. But here, Lordship, they are submitting the document, they are, both of them, Lordship, they are roaming like, Lordship, they are roaming in the month of, Lordship, 25/5/2022, Lordship. So their story is, Lordship, quite different on the basis of their record.
You have not stated that when did you appear before the, you have not stated so.
Lordship,
My lord,
the
they-
affidavit is not clear, Lordship, because.
My lord, 7/9/23.
7 and.
My lord, in
22.
the, my lord, I found the additional affidavit.
Yes, yeah. this is
Page
not a-
number 10 in my additional affidavit. Page number 10. Page number 10 down below. Here, our dates and the seal of the officer in charge signature, 7/9/23. We have submitted this, our representation along with the necessary documents to to assist with the investigation.
Lordship, let me call, well, updated case study, Lordship.
I agree, my lord. Let updated city may be called for, but till such time.
No, Lordship,
some
still,
protection.
no, Lordship, because Lordship, I have some certain doubt, Lordship, because
Okay.
this is, their
My lord,
story is quite different, Lordship.
it is not the case of the PP to doubt the outcome.
No,
of
I
the
know,
FIR. It
Lordship,
is for
but
the
Lordship,
IO to-
they are the Lordship, they
Even
have
if it is-
produced.
My lord, on the face of the FIR, no primary.
On the face of FIR only, it's Lordship, I'm submitting, because
My-
Lordship.
Case of the affair, there is a case.
Yes, Lordship.
But cannot say right now.
My lord, wrongful restraint, my lord, there's nothing. He's not some minor. Husband is not a minor and husband has not filed the FIR and the FIR has been filed, my lord, after 1 year and 2 months, my lord.
Yes.
After
That
thought.
will be Finally, at the time of final.
Then I agree, man. At least some protection, my lord. It will not hamper anyone in the investigation process, my lord.
No, Lordship.
I am
because
here on the
FIR
basis
if
of merit.
Lordship, if interim regarded FIR, the proceeding will stay, Lordship, then proceeding will stay.
Investigation will be stopped.
Yes,
My lord,
Lordship.
my lord,
The
Niharika
investigation will
judgment,
stop,
my lord.
Lordship.
My lord, when on the face of the FIR, there is no offense made out of cognizable offense.
Now, at this time,
My
I
lord,
cannot say.
my lord, it is squarely covered by Niharika instrument. Then the court,
Mr.
court.
Niharika also said that, Lordship, during investigation process, Lordship, there should not be stay, Lordship.
CD is received. According to learned counsel, it is submitted with learned counsel for the petitioner that on 7/9/23. Three of the petitioners, that is Unnati Raje Singh. Three of the petitioners, petitioner 1, 2, and 3. Never appeared before the Bhalukmung police station. And their statements have been recorded. However, learned additional PP submits that the statements that are not available in the test record. So return the text diary with the direction to resubmit the same along with the statement of the petitioners.
My lord,
Less
1,
the matter
2,
or-
and 4.
After 2 weeks, Lordship.
After three.
My lord, service of notice through OCPS.
Through OCPS,
Oh,
issue notice.
notice has already been issued. I have to take fresh steps.
Yes, learned counsel for the petitioner submits that he would like to take fresh steps against the respondent 2 and 3.
Haryana. You
Concern-
concern I don't know, Gurgaon.
2, 3, and
Person-
4, 4 also. 4 is the inhabitant of Arunachal.
No, my lord, only 4 is performer respondent. He's also one of the accused in them. Only 2 and 3.
Only 2 and 3.
And my lord, 1, 2, and 4 have appeared before the IO already. Petitioner number 1, 2, and 4.
Okay, 1, 2, and 4, not 1, 2, and 3. No, 1, 2, and 4.
So, my lord, fresh step through concern OCPS, Gurgaon,
OCPS.
Haryana.
Ah.
And some protection, my lord, at least still.
Obliged, Lordship.
Not a heinous
After-
offense. Highly obliged. Okay.
I'm appealing for the appellant.
Yes, please. You're the
Lordship,
respondent.
Lordship, I'm appearing for respondent number 1.
Respondent one.
Yes, this is my first appearance. And it is to submit before this honorable court that till date we have not yet received the copy of filing on the part of petitioner.
Copy of the petition.
Yes.
But there are 3 respondents.
Oh. 2 and 3, notice not served.
No, I may be allowed to file affidavit with regards to the justice service taken upon. 2 and 3.
Respondent 2 and 3.
Yes.
And Mr. So and so now counsel for the petition. And you are Mr.
J. Lomi, LOMI.
Respondent 1.
Yes, respondent number 1.
Respondent 1. He submitted that he did not receive the copy of the petition. Learned counsel for the petition is directed to furnish the copy of the petition along with the necessary annexures, if any, to the respondent number 1. Within 2 days, within 2 weeks. Regarding respondent 2 and 3, learned counsel for the petitioner submits that he would like to take steps to thus the mode of service.
No, my lord. I'll
Yes.
file the affidavit.
You did not file affidavit.
Yes. Some time will be given.
You already taken that
Yes, I
already
already
took
taken.
steps.
Yes, step already taken.
Only affidavit.
Only affidavit.
There is no order that thus the mode of service. Okay. Please for some time to file. You have taken steps but not please for some time to
file
file
affidavit.
affidavit after service of a notice to the respondent 2 and 3. 2 weeks? This is the matter.
Obliged.
Service were directed by order dated 12/2/23. 12/12/23. Upon respondent number 2 and 1 and 2.
Respondent 1 and 2.
I'm sorry, my lord, 12/10/23.
One and 2, respondents 1 and 2.
1 and 2.
You have taken steps.
Yes, madam. Steps were taken.
With service report regarding respondent 1 and 2. I will list the matter after 2 weeks.
Interim may be called.
Interim is there.
Yes, ma'am. My lord, may peruse order dated 12/10/23.
Interim is extended.
My lord.
May it please, Your Lordship. Lordship, in this review petition, I beg to have prayed for modification and clarification of the order dated 8/2/2024 of this Your Lordship's order, Your Lordship. More particularly to paragraph 24, Your Lordship.
In the CRP, you have challenged the order.
Yes,
dated
Your Lordship,
December.
Yes, Your Lordship. However, I'm seeking for modification, clarification of certain paragraph. Your Lordship, on the earlier occasion has put up a question if the review was maintainable, Your Lordship. I have our own judgment, High Court's judgment, Your Lordship. In this judgment, Your Lordship, what has happened, a revision petition challenging the Kaba was dismissed, Your Lordship. However, subsequent thereto, Your Lordship, the parties had come for review before the same court, seeking certain modification of the order, Your Lordship.
It is certain modification.
Yes. Yes, Your Lordship. The court has, Your Lordship is well aware in CPC, even in the judgment and order, Your Lordship, the court which has passed an order can always review its order on certain grounds that certain documents were not available during the pendency of the suit, Your Lordship, and also apparent on the face of record, Your Lordship. My review is only with regard to clarification of section paragraph 24, Your Lordship.
Paragraph
24. If I may take, Your
Of the
Lordship,
order.
of the order, 39, Your Lordship. If I may read, Your Lordship.
Yes.
In the case is that petitioner has challenged the impugned Kaba decision dated 16/2/2023, alleging that the head Kambura Tarsu, Kombo Tarsu had decided the matter arbitrarily and in an illegal manner, declaring the land of the petitioner in favor of the respondent. As no documents are held in the record regarding boundary or demarcation of the respective land of the petitioner and the respondent at this stage, it is difficult to pass any order as to who is actual owner of the land and the decision of the Kaba was right or wrong. Your Lordship may point my specific confusion is at this particular line, Your Lordship. On the basis of the oral submission of the parties and the statement of the witnesses given before the village authority, the right, title, and position of the parties cannot be declared, Your Lordship. Under this background, this court of the view that the civil courts are now functioning in the state of Arunachal Pradesh, the petitioner and the respondents are at liberty to approach before the civil court claiming their title.
So review doesn't lie.
Review
Because
lies.
no, if you want a clarification regarding any point on the judgment, the appeal lies. You can go for appeal.
No,
Then
Your
they will
Your
give it
Lordship,
to-
therefore, what my prayer is, Your Lordship. Review does not lie in criminal petitions, Your Lordship, criminal revisions even.
It's a civil
But
matter.
then review lies in the court which has passed an order, Your Lordship. My review before this court is only on certain paragraph, Your Lordship, where Your Lordship has herself stated, made an observation that the Kaba could not have declared the title and position, Your Lordship. However, this honorable court has also not only directed me or given me the liberty, but also the respondent, stating that you approach before the civil court. My prayer before this lordship is that after making such an observation, Your Lordship, the decision on Kaba has not been decided, Your Lordship. If the Kaba was right, Your Lordship will appeal it. If the Kaba was wrong, Your Lordship may quash it. Because as per my understanding of this paragraph, Your Lordship has clearly said that the Kaba could not have declared the title and position without any proof, Your Lordship. Your Lordship, in that case, may quash it. And given liberty, because the next sentence says that the civil court is still in existence, Your Lordship. In that case, a liberty may be given to either of the party to
Either of the party to
claim
appear.
title
to
before, file a title
challenge.
before the appropriate civil court, Your
Civil
Lordship.
court.
My only, because Your Lordship has not decided on if the Kaba, Your Lordship has,
Yes, I cannot say at the right, at this stage.
na,
I have seen that, I have written in that way, past to order as to who is the actual owner of the order or whether Akeba was
Yes.
right or wrong.
yes, because, why I'm saying, Your Lordship, if Your Lordship dismisses this, because paragraph 23, Your Lordship has clearly said that there is a provision for appeal, Your Lordship. Now, if Your Lordship is not, because this observation being made, that it was only on oral submission and the without any evidences, that Kaba was passed. Your Lordship has made that observation too, Your Lordship. Now, the thing is, if the Kaba is not quashed or upheld, Your Lordship, we are barred by res judicata.
Don't think so. Anyway, yes, please.
Lordship, here to my understanding of Para 24. Of course, the liberty has been given, but if either of the party agreed the Kaba decision,
Yes,
they have always right to file a appeal, which is often for us,
yes.
to my understanding of Para 24.
Now, that's why, that's the clarification. If Your Lordship has asked the parties at the liberty to approach before the civil court, Your Lordship, a certain line may be added, Your Lordship, that the petitioner, because in here both the respondent petitioners are given, Your Lordship. Only a line that the petitioner shall approach before the appellant court. Your Lordship is also aware that there was no documents, Your Lordship, and there is a provision under the Amendment Act that the appellant court may take up the matter de novo, Your Lordship. In that case, in that case, only that line need to be added for clarification, Your Lordship. If Your Lordship has directed us to appear for appeal, Your Lordship, the appellant court may take up the
I
matter.
cannot say. I
Yes,
cannot
exactly.
dictate.
Exactly.
Is in that
That is even at liberty. You can approach.
Yes, Your Lordship. Because if I may, Your Lordship, after the revision has been filed, Your Lordship, the only challenge is with regard to the SLP, Your Lordship. But in this matter, Your Lordship has given us the liberty to file a approach before the civil court. Your Lordship has also made an observation the Kaba was not held properly. My only confusion is with regard to that, Your Lordship. Only certain modification, if Your Lordship is directing us to go for appeal, Your Lordship, in that case, my petition.
Go for appeal also.
Yes, my petition may be dismissed, stating that there is a provision for appeal, Your Lordship. The party may go for appeal. Only because why I'm stressing on this paragraph is because if I go for title suit, because Your Lordship has made an observation that Kaba could not have declared. Kaba could not have declared, meaning thereby that I'll be relying on this. I will be barred by res judicata, Your Lordship, if filing for a title suit, Your Lordship. But then if Your Lordship has not at least made this observation and had given the liberty to approach before the appellant court, that would suffice, Your Lordship.
Appellate court.
Appellate court, Your Lordship. Because at page number 20, paragraph 23, Your Lordship has given the provision and the amendments that came into states, Your Lordship. However, at paragraph 24, Your Lordship has clearly stated that
you have liberty to approach before whatever you like, either appellate court or civil court. That is, the options are there.
No. Therefore, Your Lordship, if I go for civil title suit, Your Lordship, there will be a retrial, Your Lordship. But since Your Lordship has not made any observation with regard to the Kaba, if the Kaba is quashed or upheld, I will be at res judicata. Why? Because if Your Lordship upheld the Kaba and give me the liberty to file an appeal before the appropriate court, that would be a different aspect, Your Lordship. But if Your Lordship dismiss the Kaba, quash the Kaba, Your Lordship, then I can, and give me a liberty, Your Lordship, then I can go for civil title suit, Your Lordship. However, if the Kaba is not interfered with, Your Lordship, I am barred by res judicata.
I don't think it's a ground for review. Review is only at the apparent at the face of the record.
Yes,
Only
there is-
if there any mistake on the part of the parties or anything to be added.
Absolutely,
I see.
Your Lordship. My only ground is that there is a occurrence apparent on the face of the record, Your Lordship. your lordship has given observation in paragraph 24 stating that village authority could not have declared the title. Your lordship has herself stated, made an observation that this was wrong. That Kaba could not have given title possession, your lordship. Only with that, then your lordship can, in that matter, the Kaba itself is wrong. Your lordship has made this observation, meaning thereby that if it is not quashed, your lordship, the Kaba still stands. And if your lordship is giving me the liberty to approach before the civil court, your lordship, and if I file a title
Civil court
suit,
doesn't mean lower court. It may be an appellate court,
Therefore-
civil judge, senior division also.
therefore, my only clarification with this paragraph is because after making such observation, your lordship has not interfered with the Kaba at all. Your lordship has not interfered with the Kaba order at all, but the liberty was granted. But without interfering into the Kaba, your lordship has, in fact, made an observation that the Kaba has held the proceeding in a wrong manner.
I have clearly stated that at this stage, it is difficult to pass any order. Because the background of the case is like that.
Subsequently, your lordship has also stated, on the basis of the oral submission of the parties and a statement of the witness given before the village authority, the lie, title, and position of the parties cannot be declared.
Yes.
So, your lordship is herself made an observation that without any evidences, or just because taking an evidence,
Only the verbal submission. You have not recorded anything.
Therefore, I'm stating that your lordship has not interfered with the merit of the case.
Yes.
Yes. In that case, if your lordship direct us to file an appeal, approach the appellant court, because
The court is of the view that they are functioning in the state of so. The liberty was given to you to approach before the civil courts.
now civil
Either that is not clearly stated whether appellate court or civil court, that is option is there. You have liberty
yes, your
to
lordship.
file any place.
Yes, your lordship. If
At
your
this
lordship,
stage,
your lordship,
I don't think it's a
your lordship, if I may give a small this, your lordship. Now, if your lordship, I'm not saying that your lordship should quash the Kaba decision or upheld it. What I'm saying that until and unless the Kaba is not quashed, your lordship will see if your lordship dismiss my petition and upheld the Kaba, then I can go for appeal. If your lordship quash the Kaba and give the liberty to approach before the civil court for title suit, we will not be barred by res judicata. But then until unless your lordship does not interfere with the Kaba, if it does, it's to be upheld or it is to be quashed, that has not been given, your lordship. Now, only a civil reference of civil court is here. Now, your lordship has said that civil court means appellant court or either civil court for title suit. Now, my only concern is that the interference has to be done. If it is upheld, we can go for Kaba. The provision is for Kaba. If it is not upheld and quashed, then we can go for title, and liberty is given, we can go for title suit. But then your lordship has not interfered with the Kaba at all in this case, your lordship. Though liberty was granted, your lordship. That's my only
just to wait, just appeal, file
Yes.
an appeal.
yes.
Next.
Deeply obliged.
Lordship,
19.
19. Yes, Lordship. I have filed one IE application. This is
I-26,
yes, Lordship. IE 26 for
praying for additional.
Yes.
additional- Additional evidence before the appellate court.
yes, Lordship. Lordship, during pendency of this first appeal, the documents has been developed. So the respondent herein want to bring all these documents, new documents, into the records of this honorable court, appellate court.
In RFE,
I'm the respondent.
you are the respondent.
Yes, Lordship.
You are the appellant. So you want to file an objection against the prayer of the petitioner? You have no objection. So matter be disposed of. I in the matter. What are the documents you have mentioned here?
Yes, I have enclosed the documents also.
Certificate of payment, no? Annexure
Yes,
one,
certificate of payment, annexure 1.
two,
Then annexure 2 is a communication letter issued by the.
annexure three.
Yes, 3 is also a communication letter, and then 4, annexure 4 is also a communication letter by the department authorities, appellant authority.
Administer. Learned counsel for the petitioner in I 26. Learned counsel appearing for the respondents. 1, 2, 3, 4, no? You're repeating. 1, 2, 3, 4. The petitioner has filed an application under section, under order 41 rule 27 of CPC, praying for adducing additional evidence before the appellate court. It is submitted by learned counsel for the petitioner that the documents provide annexure 1 to 4, no?
Yes, Lords.
Which were not available during the case was pending before the trial court, no?
Yes. This documents was developed during pendency of this appeal.
So the documents were developed during the pendency of this, of RFA,
Yes.
pendency of the appeal being RFA number
9 of 2018.
2018. The documents provide this annexure 1 to 4. And as such, those documents are required to be proved in the case by filing in the case during, in the appeal.
Yes.
By adducing additional evidence before the appellate court. The learned counsel for the respondents has made no objection on the prayer of the petition. Hence, on prayer of the petitioner to accept the documents by annexure 1 to 4 by adducing evidence, additional evidence before the appellate court is allowed. The I stands disposed of. Then RFS, list the matter for hearing.
For hearing.
For final hearing?
Yes.
That's why also list the matter for hearing. Yes. That is in the affidavit.
Asking for permission.
Yes.
And permission has been granted.
Granted.
Now they have to file it.
Additional affidavit along with the documents
Yes,
to
in the-
bring
Yes.
the same in the court.
Necessary application to be filed. And allow me to file necessary application.
No, not application. You are-
Affidavit,
you
you
have
have
sought
to
for
file an affidavit along with certain, the annexure 1 to 4 to bring the same in the appeal,
in RFA.
in the RF. Okay.
I don't know, 15.
May pleasure, my lord, let the matter be taken up on Monday, my lord. Because yesterday I was got cold and fever, so I couldn't do my research work.
Yeah, for the petitioner.
I'm for the petition. And I have taken the consent of my friend also. 19.
Place for adjournment.
Adjournment for Monday, till Monday.
Yeah, for the respondent.
Yes, no, I am for the respondent number 1, 3, and 4. Not all the respondents, Lordship.
Not two.
Not 2, Lordship. 1.
He prays for adjournment.
Yes, no issue, Lordship. But I am representing only respondent number
Respondent
1, 3,
1, 3, and 4.
4.
Learned counsel for the petitioner prays for adjournment, which has not been rejected by the learned counsel for the respondent number 1, 2, 1, 3, and 4. Case is adjourned for today. Let's the matter after 2 weeks.
Monday, my lord.
Monday.
Monday.
This Monday.
Yes.
19-2. Oh, 19.
All right.
Much obliged.
Please, my lord. My lord, this is bail application.
Additional people? Yes, please.
My lord, this is bail application under section 413 of the CRPC. Praying for granting bail to the alleged accused Pony Hilly. The applicant is the wife of this alleged accused. My lord, arising out of 0 WPS case number 0623.
Who is the accused?
Accused is my husband, applicant's husband.
Applicant's husband?
Yes, ma'am.
Name of applicant's husband?
Pony Hilly.
Yes?
Pony Hilly.
Honey Hilly.
Yes, my lord. And the
Applicant
complainant
is
is my,
Ikha Harania. Husband, wife.
sorry, my lord.
Who is the applicant? Applicant is the wife.
Wife.
Who is the accused here?
Accused is my husband.
What is his name?
Pony Hilly, my lord. Yes, ma'am. And the complainant is my mother, ma'am. This is some certain family issues. due to which-
BW2.
Yes, ma'am.
Respondent 2. It's a matter of POXO matter, no? So notice
ma'am.
is to be issued to the respondent 2.
Yes, my lord. I'll issue notice to the respondent 1 and 2.
Third, Mr. Students will learn at counsel for the petitioner.
My lord, matter will be fixed on 21st of this month. Since
When an application for 39 CRPC seeking bail in connection with 0 WPS case number 0623 under section 363/376 in bracket 3 IPC read with section 6 of POXO Act. Call for the case diary. Issue notice to the respondent 2. With registered AD, usual process. To OC concern PS, okay? To OC concern PS. What is here? Nobody is here. You have to inform somebody that one case is coming. Yeah. Cause list. Is the matter? On 22,
21st, 2/1.
21, 2.
Yes,
Is
my
it
lord.
possible for you to serve the copy to the notice to the respondent too?
Yes, my lord. I'll serve the copy.
To say concern. There's a matter on
My
21.
lord, my lord, my humble prayer will be, scan copy of charge sheet may be called for.
Yes,
Scan copy of charge sheet.
CD is called for, no?
Okay. Much obliged.
Charge sheet has been submitted.
Yes, my lord. The case has been charge sheeted.
This has been charge sheeted.
Yes, my lord.
Then LCR,
Yes, my lord. This was it.
where it is pending? Case is pending?
My lord, it is only charge sheeted now, since the presiding officer is on leave on medical ground. So matter cannot be taken up.
CGM,
No. Especially the POCSO.
special judge POCSO,
Yes.
POCSO, special judge?
POCSO
Which
zero,
district?
zero.
Zero.
Yes, ma'am.
So charge sheet has been submitted. So LCR be required, no? LCR is required.
Yes, LCR is required.
Additional PP, preparing the same respondent one. Issue notice to respondent two because it's a case
Yes,
of
POCSO,
POCSO.
yes.
Call for the LCR from the special judge, from the court of special judge, zero.
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 From special judge, zero. Case number, even, tell me the case number.
POCSO case number 7